is Daniel Landek from the Foundation for Civic Hungary, and it is great pleasure and honor to welcome you here to our book launch. It is good to have you here today in person, despite busy politics and the COVID, which, thanks to modern vaccination, seems to be under control finally. We're happy to organize this event together with our friends from New Direction. And rule of law, what a subject. When preparing the event, I asked myself, what exactly is rule of law? How to define it? So I looked up in the Encyclopedia Britannica, and there it says, in general, the rule of law implies that the creation of laws, their enforcement, and their relationships among legal rules are themselves legally regulated, so that no one, including the most highly placed official, is above the law. Seems easy and logic, but I'm sure that the situation is more complicated, especially when the term is not defined technically, philosophically, but also politically. The term and its definition has become quite a subject these days, but one gets the feeling that it is mainly used as a political slogan or political weapon, and as such often without content, often merely as an instrument. I hope that our panelists today will put some good ideas on the table how to discuss the term rule of law with more content and give us some ideas on how to understand and use the term, especially in the context of the many legal traditions we have in Europe. Besides this complicated subject and the challenging discussion, which will hopefully cause a vivid debate, we shouldn't forget that at the moment there is a war going on in Europe, directly at the borders and in the direct neighborhood of many EU member states. And at times of war, we need to stand together as EU, as member states, as people and nations of Europe. Therefore, I would also like to ask the panelists to give some ideas on how to overcome this rule of law dispute and other ideologically burdened conflicts within the EU, which we have seen during the last years. What Europe needs now the most is, to say it with a beautiful German word, a Burgfrieden, peace, solidarity and cooperation among us, at least until the end of this terrible conflict. But now I give the floor to Witold de Chevilly of New Direction, and then to MEP Kinga Gál, who also serves as Vice President of Fidesz. I wish us all an interesting evening. Thank you.
Dear members of the European Parliament, dear ladies, dear gentlemen, dear friends. On behalf of Tomasz Poręba, President of New Direction, I would like to say that I'm very pleased to welcome you tonight for this event. I would like also to say thank you to the Foundation for Civic Hungary. Thank you, Daniel, for this opportunity. We are very pleased to co-host this event with you. Hungary is a key country when it comes to conservative values in Europe. I hope it won't be the last event that we host together. Instead of talking about the subsidiarity and the rule of law, we have great experts. I cannot compete with them. I would like to say a few words about Ukraine. Indeed, we all know what is happening. We are all very busy with the aggression of Russia in Ukraine. And to be honest with you, it seemed to us a bit trivial to host this event. Indeed, while everyone is focusing on that, we will talk about rule of law, an internal issue. Of course, it's still very important, but I would like to say that even though subsidiarity is at the core of our business, we will always be focusing on the war in Ukraine. We have set up this morning monitoring of crimes committed by Russia in Ukraine. It's public, it's open to everyone. We would like to make sure that everyone knows about the crime against the civilian, the refugees. At the same time, New Direction will make a donation to the Ukrainian embassy in order to help refugees on the spot. it's not a surprise for New Direction, for the ECR family, ECR group, the ECR party. We always took a very hard line on Russia, and it's sad to say, but we are not surprised. However, today we will discuss the subsidiarity. Maybe we'll make a link with what is happening in Ukraine. We have seen last week member states very active. They reacted very quickly. They offer help to Ukraine, while at the EU level it took a bit of time. So maybe we have also to think about that when we discuss subsidiarity. Having said that, as you know, New Direction and its president, Tomasz Poręba, are very committed to make sure that New Direction is and will remain a platform open to everyone, where people can express their own voices. I would like to finish by saying thank you to the speakers. Thank you very much for coming tonight. Thank you to the guests. And I would like to invite Ms. Galt to the lectern. Thank you.
Distinguished guests, dear participants, thank you to be present in such a nice number, and thanks for the participants for their presence here. It is a pleasure to speak at this event today when we launch an important book of a young author. I know Mr. Gát personally for many years now, since when he was a trainee in our Hungarian delegation in the European Parliament in 2014. In 2016, he completed his special internship at the Secretariat of the Committee on Legal Affairs as part of his studies that time at the French School of Public Administration, ENA, and Paris One Panthéon Sorbonne University. In 2018, he returned to the EP once again and served as member of the cabinet of President Antonio Tajani. Despite his young age, he showed a rather serious interest in the questions related to the rule of law, with special regards to the case of Hungary. And his sense of justice, as my sense of justice and many of others, made very interested in what's going on against Hungary and what outburst is against Hungary in the so-called rule of law. I remember well those times, as I was vice chair of the Civil Liberties, Justice and Home Affairs Committee, the main venue of the rule of law debates in the European Parliament. During those years, when Bence was in Brussels, the continued attacks against Hungary amplified yet once again. Libe hearings, plenary debates on Hungary, and the preparation of the Sargentini report were all on the table. But then, the main sense of these ideological debates was the European Parliament. So, Bence realized ahead of many that it was the start of a longer ideological debate. And he was present in Brussels to personally witness those processes at crucial moments. The subtitle of his book, A Glimpse Behind the Scenes, was not given by chance. I would like to congratulate hereby to this synthesis of the recent and ongoing European debates related to the rule of law. The young author delivered such a book that gives a truthful and authentic background to the ongoing debates for those who are interested in the facts, not only the usual melodies of mainstream media. Mr. Gát has a very important skill, the critical thinking. I remember talking with him back then when he was collecting the material to his master's thesis in French, which is the basis of this current book in English. He would interview several stakeholders representing different approaches or ideological perspectives. Thus, he not only approached the topic from a professional point of view, but from a practical, analytical direction. The result is a true guide that is easy to understand and enjoyable to read. Looking at the topic, this is a huge achievement in itself. What we are witnessing these last days, as my previous speaker told and my colleague told you, shows that now it is more important than ever that Europe stays united. There is not the time for ideological debates and witch hunting. No member state should be named or shamed on ideological basis. The current book is an instrument to a better and more objective understanding. Congratulations to the author who was brave enough to think outside the box step out of the mainstream, even if this can sometimes be risky, also in the academic world. Gratulálok, Bence.
I would start with the decision of the European Court of Justice just a couple of days ago, when the European Court of Justice dismissed the case of Poland and Hungary on the question of whether the rule of law can be a condition for the payment of EU funds. Is this really a decision, what the decision was about? Or was the European Court of Justice making a political decision and acted as a political actor, which we already experienced or witnessed several times before? For example, when, at the beginning of the migration crisis, and when the Hungarian position was against of the mandatory quotas, distribution quotas of migrants. Firstly, please, Mr. Tocsány.
Many thanks for this invitation. First of all, I would like to congratulate Bence. Bence was my former student, because when I worked as ambassador in Paris, he was a student at the École Nationale d'Administration, and we worked together also in Paris. He was always interested by the rule of law and the decision of the Court of Justice and so on. And he made a very good job in the embassy also. Okay, but I think it's very important to define also the circumstances, because we live in the very difficult period. The world is troubled at this moment. There are so many crises, and the circumstances always very important, because the judges also read the newspapers, and there are so many crises in Europe today. This started, of course, in 2005 with the referenda in Poland, in France and Netherlands, and after that the crisis in Greece, the euro crisis, the economic crisis, after the migration crisis, Brexit is most important, and today there is the war, a pandemic, and so on. It means that the world is troubled, and Europe also is troubled at this moment. The situation is very difficult, and in these circumstances, it's very important to see also that the different European institutions started to show some guilty country also. Some guilty country. The guilty country where there are the right side government. It is a reason that in Poland especially and in Hungary, and sometimes in the other countries also. But this debate, the rule of law, started the beginning on the maybe 2013, 2014, and there are so many rule of law mechanisms today in Europe. It means that the Commission adopted in 2013 a communication about to strengthen the rule of law in Europe, and after that today there is also the rule of law, how can I say in English, rule of law report prepared by the Commission. The Venice Commission prepared also a checklist about the rule of law, and the rule of law became a Bible, a new Bible in Europe. I understand, of course, that there are some questions, but we can agree, of course. Independence of the justice is very important for everybody, because without independent justice, we cannot work. The separation of the power is also very important in the world, the free election also, and so on. I can enumerate a lot of characteristics of the rule of law. But the problem is that the rule of law received the ideological aspect. The problem is when I read this decision of the court was unable to give the decision of the rule of law. This is the biggest problem in my mind, because we agree that we have to fight against the corruption. We have to protect also the financial interest of the European Union. Of course, every country has an interest, of course, to protect the financial interest of the European Union. Okay, but what does it mean, the rule of law, when I read this document of the decision of the court, I can read this sentence. Accordingly, but notwithstanding the fact that the Commission and the Council must make their assessment, taking due account of the specific circumstances and context of each procedure conducted under the contested regulation, and in particular taking into account the particular features of the legal system of the member state in question, and that discretion which the member state enjoys in implementing the principle of the rule of law, that requirement is in no way incompatible with the application of uniform assessment criteria. But when I read this sentence, nobody knows what the court wanted to say. And this is the biggest problem, because on one hand, the court accepts the particular features of the legal system of the member states in question, discretion which the member state enjoys, but on the other hand, of course, they gave the uniform assessment criteria. It means there is some contradiction. On one hand, okay, there are some differences, and on the other hand, okay, there is the unique assessment. And this is the biggest problem, because I agree that we have to protect the European budget. Okay. But on the other hand, after that, the assessment, unique assessment, when the circumstances are different, and we know also that there are rule of law, Rechtsstaat, état de droit, and so on, the different notion of the rule of law in the world. It is impossible to make, to do unique decision of the rule of law, and the court was unable to do this. And this is the biggest message for me, that, okay, this is the decision, this is obligation for us, but on the other hand, there is no decision. The question will be, I think, the true debate will start now, when the Commission would like to start a procedure against one country, saying that the rule of law was destroyed and so on. And after that start absolutely the new debate, concrete debate. What does it mean, the rule of law? It means the court was unable to give a unique decision of the rule of law. This is my personal view.
Thank you very much. Please, Mr. Legutko, express yourself.
Well, first of all, let me congratulate on the book. It's so important that there are people, young, bright people, who can produce their works from outside the mainstream, because sometimes you have this depressing impression that everybody is of the same opinion, especially if you work in the institution, in the European institutions, that the dissent is not welcome. Now, what you said, you quote this part of the justification, right, of the verdict. I suppose you, as a professor of law, you would have failed a student who would come up with an argument like this. I mean, this is gibberish. I mean, come on. And I'm not a lawyer, but I will make a more general statements. Why I see that the rule of law has gone to the dogs in today's world. There are at least two reasons for this. There are many reasons, but two reasons. One is that we've lived in the world which developed a kind of social, political, and cultural philosophy which slightly resembles Marxism, where law is interpreted as or defined or perceived as an instrument of change. Right? You do not really regulate, but you change the world. Following the political movements, right, feminism, LGBT, things like this, right? They are dedicated to restructure the society, and the law and the lawyers and legal institutions want to take part in this change. So that's the original sin, because the lawyer or the legal institutions feel entitled to bend the rules, to reinterpret them in such a way as to make the desired change, right? With respect to a certain political or social purpose that is to be realized in the future. If you, I think Article 5, the Treaty on the European Union, is about the ever closer union. Now, ever closer union is an invitation to the violation of law, right? Because what it means is that every regulation is just provisional, temporary. In fact, you are encouraged to twist these rules, because the more you push the world towards more Europe, as we say in this awful jargon, right? The better. You are encouraged to do it, and the European Court of Justice is precisely the institution that works towards that objective. I do not know, you are more knowledgeable on the point, gentlemen, than ladies and gentlemen, than I am, but I know of no case where the European Court of Justice issues a verdict against the European institution, as the encroachment of the European institution, right? The principle of conferral, proportionality, right? Subsidiarity, where they say, okay, you commission, you push too far, right? Go back, yeah? This is none of your business. Maybe there are such rulings, I don't know, never heard of them. And the second reason why the rule of law is shambles, especially in the European Union, is that the category of the rule of law was invented and perfected and applied in nation states, with all these arrangements which you mentioned, right? Separation of powers. Well, yeah, we all know that. The problem with the European Union is that not only does it not is it not a state, right? But the political and institutional solutions that are there are in contradiction with those principles on which we constructed nation states. So take separation of powers. What is European Commission? Executive, okay. But legislative, in a way. Judiciary, perhaps, right? European Parliament, like European Parliament. Parliaments are institutions that exist in nation states when there is a demos. If there is no demos, there is no state, there is no room, there is no reason why there should be a parliament. If you have about 700 right, deputies, about 50 are representatives of Poland, which means that 650 deputies decide on the matters relating to my country, being absolutely not accountable to the voters. I mean, they can do whatever they can. I mean, this is the very contradiction of parliamentarism. So I would say that rule of law is entirely alien to such institutions as European Parliament and European Commission. I mean, they just do not know what it is. And their raison d'être, their way of functioning, is possible only by rejecting all these restraints and limitations. And I think colleagues from the Parliament will probably agree with me to some extent. And I will stop at that point. Believe me, I can talk a lot more.
Thank you very much, Mr. Legutko. Please, Mr. Buxadi, share your thoughts with us.
Well, first of all, I would like to thank New Directions for the invitation, the Hungarian Foundation, the author, and I would like to thank you for giving me the opportunity to take the floor in Spanish, which is a true luxury to me. It's an honor. After these two presentations, there's nothing much that can be said. I would like to insist on the same points. I believe that the Court of Justice of the EU has really become, over the past few years, it has become an instrument to destroy the order that we find in the European communities and the destruction of the sovereignty of our nations. As Mr. Legutko very well pointed out, the rule of law, the supremacy of law is a concept that was born in nation states, and it makes sense in nation states because nation states have sovereign parliaments that can pass laws that are then applied by states and by governments, and then the courts are the ones that check on the legacy and the compliance of law. If we look at this ruling, and if we look at the case law of the Court of Justice of the EU, we see that the Court of Justice of the EU has the aim to destruct these conditions. So we must point out that the Court of Justice is not an instrument at the service of law. It is an instrument at the service of certain political elites, and it attempts to destroy these concepts. In terms of the supremacy of the law, we spoke about the crisis that we faced in 2013, and I would like to really stress something that my party in Spain, Vox, has been working on, the agenda, 2030 agenda, which is the gigantic project to promote a single ideology that would be imposed in Europe, in Asia, and in Africa. It takes place over a period of time, and it aspires to remove any nation from its own singularity, its own unique character. And they've used the rule of law as a weapon, rule of law as a series of European values. Mr. Macron tells us that abortion is a European value, suddenly, whereas it was never. It never was and will never be a European value because it is anti-human and attempts against the respect of human life, at least according to Spanish doctrine. I'm not sure how this is in other nations, but the respect of human life is the basis of any rights. If we don't have respect for the dignity of humans, the respect towards families, towards international communities, we cannot have rule of law and we cannot have respect. And I believe that we need to be very aggressive on this because it goes against the project of the treaties. The discourse that we see in the Court of Justice throughout its rulings is very disappointing because it falls into politics. I am a legal specialist, and I think there are problems to this, legal problems. The primacy of constitutional law. We need to insist on the fact that this is above the treaties in all cases. And so in the case of Spain, if we look at primacy of law, if we look at the norms that establish the life of Spanish citizens is based on the respect for life. And we have the regulations that are controlled by European institutions. And so the Court of Justice wants for our life, all of our life, to be regulated by community rules. And then a small space is given to national rules. and national norms. And so it is taking from national law and taking into the European law. If we look at the legal tradition in Spain, in France, in Hungary, in Spain, they are completely different. And I would like to conclude with this. The Court of Justice has existed for 40, 50, 60 years, whereas the Spanish Supreme Court is rooted in courts from the year 1500. More than 500 years of history give it its legitimacy. And now we see this European court that is entitled to decide if a directive on the measurements of chairs or the distance between doors is compliant and has to be imposed for all Europeans is absolutely reckless and ludicrous. And so I think we need to put an end to that debate. I believe that we need to insist on national sovereignty, and we need to insist on the fact that countries are the very owners of the future because they have a legacy, the legacy of the past and of national history.
Because yeah, please go ahead.
No, I have to leave.
That's the reason why.
To speak a little bit
Please.
more. Many thanks, because it's quite interesting to speak about the court. The discussion about the court is always dangerous because everybody used to respect the judgment of the court, and to criticize the judge is always very difficult in every country. It's not only European level but national level, because we can criticize also the politicians. We can criticize also the government and so on, but the judge are judge. It means that there are some cautious also whether we would like to criticize the judges or not. But today we can see a very interesting debate among the judges at national level, at European level. If you can see the different decision of the Constitutional Court show clearly that there is a true debate among the European Court and the Constitutional Court at national level. Why? Because the Constitutional Court would like to check whether the European institution respects the competencies or not. This is the ultra vires issues. The second, this is the constitutional identity question. The constitutional identity became a very important notion in the last decade. You can see also the decision in France, also the Conseil d'État. The decision of the Conseil d'État in France about the national security, for example. I can see also the Polish, the Hungarian, and the German Constitutional Court, which decided protecting the constitutional identity of the country. And the third also is very important, the efficiency of the European legislation. As you see in the migration, there is, of course, the legislation about the migration. But the efficiency of the legislation is very bad. And when we transfer the competency to exercise the command, we wanted absolutely efficient exercise of the competencies. Today we can see that, okay, the European level is not efficient. Maybe we can exercise this competence at national level. It was the decision of the Hungarian Constitutional Court. It was a very important decision. And when we speak about the dialogue among the judges, today it is only vertical. And dialogue, in my mind, it is not vertical but horizontal. And today is missing, there is no possibility to create a good dialogue among the judges where the member state or the Constitutional Court say that we would like to protect our constitutional identity. In this case, the European Court has to accept this interpretation because only the Constitutional Court can interpret the national constitution. It is very important to know also, because if the court would like to analyze the national constitution, it's very dangerous, because the court can interpret only the European legislation, but not the national constitution. It means for me, if the Constitutional Court say this is our constitutional identity, in this case, in my mind, the European Court has to oblige, has to accept this interpretation. It is very important. Of course, it is, I know, and we know also, that the more federative institution, this is the Court of Luxembourg. It is clear. It is clear. We know, of course, all the decision, the Costa Engel and so on, the supremacy of the EU law, as you mentioned also, but it's quite interesting, this missing in the treaty. Why the European member states didn't want to put in the treaty? And this is the reason the supremacy is not absolute. Not absolute. This is my personal interpretation.
I will give you the floor before we are running out of time. But would you like to react, one of you, Mr. Legutko or Mr. Buxade, to those that have been mentioned by Mr. Chochan?
Solo quería decir un dato.
I just wanted to mention a number. There is a law in Spain that says that the constitution is above the treaties, and it's from 2014. And most Spanish politicians say that the treaties are above the constitution, which is the other way around. I mean, this doesn't make any sense because they're all aligned with a specific political goal, which is to give all powers to the Commission and to the Court of Justice of the EU. It is difficult to criticize judges, but that's what we're here for. Of course, we should criticize judges because sometimes the rulings are unjust, and this is what is happening with the Court of Justice of the EU. All of its decisions are unjust. There was a recent one, a ruling that said that Hungarian law was contrary to European law when forcing NGOs to point out that they were receiving foreign funds, and it said it's against the treaties. Which treaties is it against? I mean, they need to be specific, and this needs to be stressed. I'm not sure as to how the magistrates are chosen at the Court of Justice, but I know that in Spain they're appointed by the government by looking into political criteria. So why do we speak about judicial independence if the magistrates of the Court of Justice are appointed by the governments of the countries? I mean, this is something that needs to brought to light. And we believe in justice, and we believe in a project that is based on common sense.
Just a short point. We had the primacy of European law, as you remember, the Constitutional Treaty, and then it disappeared, right, from the Lisbon Treaty. And there was a reason why it disappeared, because the member states didn't want it. And then I think it reappeared in some of the rulings. It is the judges themselves who introduced it. And now we have the European Commission, we have the European Parliament, and you can see the unholy alliance, right, of the judges who take the decision-making power. It's not in their prerogative to make laws. They can interpret laws, not to make laws, introduce them through the back door, and the politicians from the Commission, and then they say there is the primacy of the EU law. If you do not agree, you will be punished. Is that the rule of law? It's a farce.
The author, Mr.
The author.
Thank you very much. I'm honored to be here, and thank you very much for the organization of the event. Dear Mrs. President, there was nice words from Kinga Gál about my book and the job I did. I'm really honored by these words. And let's say that now I have the opportunity to do the same thing that I did in my book. I've listened to politicians, institutional actors, and then I tried to make a synthesis, and also I tried to develop the background of the things a bit. This is a nice opportunity for me because I'm a writer, and now I'm a writer who is now present in his own book, because in my book the actors are the politicians, and now I am with the politicians. So I'm kind of in the topic of my book. The first question was about this rule of law judgment of the European Court of Justice. I would say that this is a point that comes after at almost a decade of developments. And in my book, what you can find, this is a guide, a documented guide with all the steps which led to this situation. It started back in 2013 when the 4 ministers of foreign affairs wrote a letter to the president of the European Commission, back then José Manuel Barroso, and they asked for the development of European mechanisms in the name of the rule of law. In 2014, the Barroso Commission, at the very end of his mandate, came out with the so-called rule of law framework. That was the first. That was the first mechanism the Commission foresaw in order to observe or supervise the rule of law, the situation of the rule of law in the member states. At this moment, it is very interesting what happened. The legal service of the Council developed a legal argumentation, a piece of a legal paper with arguments, claiming that what the Commission does is against EU law, because there is no legal basis for the action of the Commission. The legal service of the Council wrote in his paper that the Commission is not allowed to supervise the rule of law situation in member states, even if it is about issuing non-binding opinions about the rule of law. And if you compare that back in 2014, non-binding rule of law opinions are also unlawful, are already unlawful. Let's compare it with the current situation when we are talking about financial penalties in the name of the rule of law. It is logical from a lawyer's perspective that if back in 2014 what the Commission did was against the EU law, so the EU rule of law, it should be against also in 2022. So when I observed the different steps and developments of what in the name of the rule of law was done in the European Union, and which political actors, institutions behaved in which way, I found contradictions. And it's worth to read what are these contradictions, because rule of law debates are current debates, we are listening to them in the media, we are hearing about them, we have an opinion about them, but we tend to forget what was at the beginning. And I think it's useful to have a documented version of what happened in the last decade.
Thank you very much. You mentioned several times the Barroso Commission, and my second question, yes, it's going to be the second one only, or maybe a third, would concern this issue, because Hungary has been in several sharp disputes with the EU institutions during the Barroso Commission. For example, the new Media Act or the retirement of judges, which were all settled. In worst case, by the Court of Justice, and Hungary complied with its ruling. Although the treaties that have framed the European discourse have remained the same since Lisbon, At the beginning of the Juncker Commission and 2014, the dynamics of dispute settlement between the Commission and Hungary, and since then Poland, we can say as well, we can add this well, seem to have changed. Has it really become more difficult behind the scenes? And if so, what's the reason behind this?
Yes, I think absolutely, because the Barroso Commission back then was a commission which was closer to the original role of the Commission, which is the guardian of the treaties. So that explains why the Barroso Commission had a more legal approach, and they tried to settle in a legal way the disputes that are raised about issues such as the Media Act in Hungary or other issues. The Barroso Commission was efficient in this way because they tried to attach themselves to EU law in a way. But what happened after 2014, when the Juncker Commission came to power, is that the President himself declared that this will be a political commission, a political body. Indeed, a highly political body. These were the words of the president of the commission, of the Juncker Commission, and that is the big change in the relation of powers in the European Union. That the Commission started to behave as a political actor, and since it is a political actor, it can no more fulfill at the same efficiency its role of guardian of the treaties, because it has a lack of objectivity since it is a political actor. And what are the other institutions that take part in defining the rule of law and in defining the rule of law and in deciding about in which countries which decisions are against the rule of law and which decisions are not against the rule of law? These are all political bodies, almost all political bodies. The Commission declared itself a political body. The European Parliament is by definition a political body with MEPs, elected MEPs, and we have the Council government representatives. This is a political body, and now we have the question of the Court of Justice, but here as well we can say that even if this is a body that shows more signs of independence because it's conceived like a judicial body, it has also, from a political science view, its own interest and its own political interest as well. So that is why that I think that the academic world should also can be critical with the European Court of Justice as well. Here in Brussels, there are a lot of criticisms about the European Court of Justice, but what they say, because they are the mainstream criticisms, the Court of Justice should have gone further in federalization. If we can criticize the Court of Justice from this point of view, we can also criticize the Court of Justice saying that it has gone too far in the federalization.
What about the Polish approach, Mr. Legutko?
Well, we came up after Hungary, and they were probably they found out. I mean, the EU people found out that they were too law-abiding, right? Too in accordance with the rule of law. And so when the Poles came and said, no, we won't make that mistake anymore, and we'll give you a hard time. And it's clear that they are doing it. So let there be no misunderstanding. The job of this institution is to topple the governments in Poland and in Hungary, and they will do everything they can. Law or no law. Now, as I said, law doesn't really matter. Doesn't really count. I mean, if everything is politics, law doesn't matter.
Mr. Buxady, the floor is yours.
Well, I would just like to reflect on this because I have already criticized the magistrates in the Court of Justice of the EU. I have another reflection that another thing I would like to reflect on. If we look at the structure of the Court of Justice, it is based on two principles: the principle of direct effects of European norms and the primacy of European law. We see two rulings or decisions, the Cimental decision, and we need to explain everyone that these two rulings are from when the European Economic Community was operating from the basis of unanimity, and there was no European Union back then. From the 80s, 1980, things changed. Hungary and Poland were not part of the EU. Spain, Portugal, and Greece were also not part of the European community. It was a very small community with very clear competencies, very clear powers, and it was very clearly established where the European community was working. And it made sense. If we said that all governments decided to apply a common goal, then the community's rules could be applied. It is not this way nowadays. We see that many decisions come from the institutions and being applied against the government's, the member state government's will. And this has no fundaments. We must insist on the fact that there is no effort of doctrine in the Court of Justice. If we look at Spanish, Italian, many judges that are making incredible efforts every day. And if we look at these decisions of the Court of Justice, it tries to revise two rulings, and it establishes the primacy of EU law. And since the Council and the Commission have spoken in a certain way, it is something that has to be respected. It's something that we need to fight against, because there's been many generations of political actors, young intellectuals, university lecturers that have not fought against this idea. And thank God, thanks to Hungary, to Poland, that are now fighting this battle, we are able to reopen the debate, because during 20 or 30 years, nobody decided to debate on this. It is now high time to talk about this, to put this on the table, because it is about justice. And I'm very happy that Poland and Hungary are now talking about this, so that once we win our elections in Spain, we can also work at this level.
Our next question would be about the book, your book. I will quote some words about it. So you mentioned that, quote, the European rule of law debates have seen the formation of two main opposing camps. The first camp seeks to keep the issue of European rule of law control over member states on the European political agenda. The other camp does not agree with such an application of the rule of law and is therefore skeptical about European policy on the rule of law. What do you think? And this is to all of you, of course. Which camp will succeed in the long run? And what can be done to make the second camp larger, maybe?
Thank you for the question. That is a good question, and the answer is the competition. They have to fight. They fight with a political fight, of course, I mean, against each other, and the stronger one will win the battle. But why I am speaking about two camps, and I think that it is an original approach in my book, because if we read analysis about rule of law in the European Union, rule of law mechanisms, in general, in the academic field, the studies are about the question how the European Union and the European institutions could have more efficient means in order to exert political pressure on member states. So how the EU could have these instruments? And I think that this is not the number one question. The first question should be why the EU wants to have such instruments. And there is a debate, because there is a camp which says the EU needs such instruments because there are rule of law shortcomings in member states. Okay, this is one camp. We can respect this position. We are Democrats, so we respect this position. But there is also another camp which denies this position and says there are no rule of law shortcomings. At least there are no such shortcomings in the member states that are criticized, in Poland, in Hungary, or in each cases. And why my book can be interesting in this circle as well, because my book gives the opportunity to the second camp as well, that the gentleman represents as well, to have their word. And I am analyzing this battle between the two camps and the reasons behind the behavior of the one camp and the other camp. And this is different from the mainstream analyses. How the second camp, so the one skeptical with the European rule of law instruments, can be stronger. I think that maybe it's not a question of number, but this is a question of unity. They should discuss with each other more. They should define the common objectives. They should find the common ground, and they should show unity in order to face the other camp, which is quite united in this rule of law question.
Mm-hmm. Mr. Legutko.
Well, I think that there is a symmetry between these two sides. I mean, the one is extremely powerful and has lots of instruments at their disposal, it looks bad. I don't think that it's a competition, at least not intellectual competition. There is no, I have a better argument. If you mentioned these opinions of the Council's opinions on the rule of framework. One was 2014 and the other, I think, 2018, and they were very, very critical. So what? There is such a thing as a shredder. You put it into the shredder and the problem disappears. Why bother to compete? You just can silence, intimidate the other side.
Mr. Buxade.
Yo creo que...
Well, I believe that we've already started the path. We're already in the path towards winning, towards competing, towards fighting. And I agree with the book's author in the fact that unity, cooperation, exchange of information, exchange of knowledge is absolutely fundamental. There's another important element, never to give in. We must never give in, because of course they're a lot more powerful from a financial, political, social point of view, but they face a problem, and it's the fact that they don't have truth on their side. They're not right, and so we need to defend reason, defend common sense, defend reality, and to insist on the fact that if there's faults and if there's gaps in the rule of law, it is at the very EU, at the heart of the EU. What makes does it have to have a directive that goes against national law? What can we do to fight against the resolutions of the European Parliament? Because if the president of our parliament says something against the chambers, we have clear procedures to repel these decisions, and this can lead to very quick processes. How can we defend our fundamental rights in terms of having access to a building, for instance? What can we do when these reports from the Fundamental Rights Agency are published? this organization needs to be denounced because it is attacking fundamental rights, the fundamental rights of Europeans. It's attacking our culture and the decisions taken by our national parliaments. And so with that steadfast will, we can win. We see places such as Hungary and Poland, which is the examples that we analyze. We see that we have governments and that are taking decisions, and these decisions, these governments are in power. Our decisions are in power. We are not in power in Spain, and that is our goal. We need for our decisions to get to power, because in the end, in the council, is the one that has the most power. So we need to work on this at national level. Vox is a political party that within the last 35 years was able to pronounce this discourse. There was no other political party that did this in Spain. And I believe that there will come a point in which 45% of the Spaniards will agree with our arguments. Yes, differences between fields is true. Just a few sentences in Spanish. I believe that there's a difference between the two scenes. We have a national scene and an international scene. And the power that is present in each one of them is different. The national field in Hungary and Poland is stronger. We have the ruling powers chosen by the people. And so the rule of law, which is the first field, can be very powerful at European level, but cannot win, because in these countries we have governments that are in the second field and that are in power. And so we see differences.
And I write this in my book, that one of the camps can only succeed and only claim itself winner if they win on both national and European level. That is why there is so much pressure on such member states than Poland and Hungary.
Thank you very much. As we are, as time flies and we are almost running out of it, one last question we cannot avoid because of the current situation concerning the war. Is it really the time of using Hungary, Poland as a punching bag concerning the rule of law issue always? Is it really the time to cope with this rule of law issue?
Well, the answer is no, but it's sort of obvious no. But doesn't matter. I mean, we are really the enemy is number one. Okay, nowadays Putin does not have a good press. And I'm just wondering for how long and when it will change. Come on, he's a rational politician, you know. We have to go back to the negotiations, compromises on both sides, sanctions hurt our industry. So I wonder when it will change. I don't want to sound too cynical, but something is telling me that they won't stop Poland bashing and Hungary bashing. It's the priority. You know, they get when you see them, at least in the parliament, when they talk about Poland and Hungary, they get sort of ecstatic. You know, it's.
Sí, yo también creo que esto no ha acabado.
Yes, I also think that this is not over yet. I'm quite new at the European Parliament, and one of the most interesting things for me is that in every plenary meeting there is a debate against Hungary or Poland, or otherwise against both of them at the same time. It's always there, and I don't think this is going to change. It's quite surprising that in the last plenary session in Strasbourg, where Putin was already so close to the border and they were really threatening, and the debate was about Hungary and Poland and the rule of state and so on, and we weren't really talking about the things which are important for us: the defense, the protection of our borders, security and life of our citizens. I also have to say that this is an opportunity to teach and to be, as politicians, teaching things in our countries, because we can use this occasion to explain things. It's so appalling that Putin was there, close to Europe, and in Brussels we were talking about what happened with judges in Poland and whether they were appointed in a 3 or 4 month procedure, or that in Hungary lobbies and LGBTI couldn't get into schools. And we have to explain that to our citizens. Because there is one thing which is what interests to the elites, and there is another thing which interests those who are there in the street working. And this is a good opportunity for us in order to show our speech, to be pedagogical, and to see what happens in the next mandate in 2024. We need to be the first political force at the European Parliament and to have a real strength.
The crisis is very serious during this war situation, and since we have a real issue, a real problem now with the Ukrainian-Russian war, maybe those more ideological debates, such as the debates about the rule of law, should have less weight in the European public debates in the European Parliament. But there is two ways. Maybe they will not increase, but decrease. Maybe they will increase. We do not know. But I'm a bit pessimistic as well, because what we saw during crises. Let's take an example: the migration crisis. The EU was not united, but that was a time back in 2015 when the most division appeared in the European Union. But okay, it was about is migration a problem? So there was a problematic about the definition, is there a problem or not. But let's take another example, which is the coronavirus crisis. It's evident that this crisis touched all the member states in an equal manner, because the virus didn't choose between political parties, between member states. It was dangerous for everyone. And it was a really bad experience that by that time that each country tried to protect itself against the pandemic, the European Parliament, which worked, by the way, in a standby mode because the European legislation stopped for a while, they continued with attacking Hungary and Poland. And there was some weeks when the main job or the main work of the Parliament was concentrated during the first time of the coronavirus crisis. They were concentrating their efforts and criticizing Hungary and criticizing the Hungarian law, which was conceived to protect Hungarian citizens against the virus. So now there is another serious issue like the coronavirus. Now we have a war, and European leaders have the choice whether they follow this, I think, irresponsible way of doing politics, or they will change their mind and they will concentrate on the war and less on rule of law issues. And one more maybe conclusive sentences or idea from my part. I think that in the European Union, we cannot do politics in the same way that we do in member states, because the European Union is constructed by different nations and different member states. It means that I think that by its very nature, in European politics, there is a dimension, there is a component of diplomacy that should stay, because if there is a dispute in the Council, it is among member states, so there is a diplomatic question. But if there is a dispute in the European Parliament among political parties, political groups, represent MEPs representing political groups. They also represent their own country. So when I see an MEP criticizing very hard with a very hard critic another country, I see there is a diplomatic problem because every nation deserves respect, and I think that even in the European Parliament, we should give this respect to different representatives of different nations, and including the prime ministers. When Prime Minister of Poland or Hungary come to the European Parliament, it is not normal that they are attacked like enemies. They should have more respect in the mind of MEPs as well. I think that serves more European unity than going to party political, ideological battles such as in member states, because in member states these are the representatives of the same nation. This is another question. But at the European level, there is this diplomatic problem as well. And diplomacy is very important. This is what makes unity.
Thank you very much. Actually, we are running out of time, so please, I would like to ask Mr. Legutko to deliver his closing remarks, and I would like to thank all of you for your participation and your thoughts. And after your closing remarks, we are happy to have you for our short reception here.
Okay, thank you. I mean, these were most interesting contributions. I think politics is the key word. European politics, European Union, European institutions have become not only political but partisan. And in fact, the institutions have been captured by a coalition of parties of movements, and they imposed their ideas and their politics on the rest, including law, right? And since they have gained majority, we have something like tyranny of the majority in the European Union. That is, you cannot really raise, I mean, you can, but it would be useless to raise legal arguments because your arguments will be taken up, right, and rejected if you do not belong to the same political camp. Those who make the law, those who make the decision, are the same people that belong to the same group. Those who control or who interpret. So, if you are not inside the mainstream, your possibility of influencing is limited. I mentioned those two legal opinions. They were just simply got rid of. For some time, you couldn't even find them. I mean, they were supposedly somewhere, right, on the council website. You couldn't find them. They just disappeared. And then when they reappeared, they were really ignored. I mean, who cares? I may say, I may give a shout at the European Parliament. Those two legal opinions, do you remember? It's all illegal. So they will, take the janitors or whatever they call, right? And they let me out. I will be punished. I will take 10 per diems, right, as a form of punishment, and that's it. So, and then it was said here that judges cannot be criticized. Well, traditionally, well, they can. They can be criticized. Depends which judges, right? If you are in the camp of light, of course you cannot be criticized. But if you are a member of the Polish Constitutional Court, you are bullied, you are insulted by the political bodies, right? The president of the Commission the President of the Commission, ostensibly an executive body, dares to attack Polish judges. And it doesn't occur to her that there might be some kind of contradiction. Right? The judges should be independent, so there shouldn't be any pressure from an executive body on the judges. No, they should be. Right? Of course they should be, because they are the wrong judges. So, and the politics that has contaminated a European institution is the politics of the left, because the mainstream is being dominated by the left. And you know, the problem with the left is that they believe in progress. So the conservatives can agree that there are people in a society who are not conservatives, and that they have a right to live, to have a representation. But if you believe in progress, why do you need all those conservatives? They will disappear sooner or later. They will die out like dinosaurs. There is no reason why you should compromise. They should simply die out, right? Also, at first they should be silenced. So I'm saying all this, but it's really makes a very depressing prospect for the European Union. Just one example about this law and politics: conditionality ruling, from which you started. Okay, the European Council, there was this agreement, conclusions that it should concern only financial matters. Why should it concern only financial matters? It's kind of obvious. I mean, you need have another mechanism, right? Conditionality. And there was this ruling, which, if you read the text, apart from those silly statements which were quoted, it also says that should be applied to financial frauds, right? Mishandling of finances. But the entire political spectrum, the mainstream, were absolutely delighted. They were delighted not because the ruling said that it was only about the financial questions. They were delighted because they knew very well that they could abuse it, right? That they could, sorry, thank you. That they could, you know, strain it and use it as a stick to beat the dissenters. So ultimately, what it comes to, what started with politics, should end with politics. That is, as Jorge said, as you said, as I'm saying now, not much will change until there is some kind of political equilibrium. Not much will change until the political scene will be balanced to the degree that the other side will know that they will not get away with what they are doing. Now they know that whatever they do, they will get away with it. And we have too little power to block them. So politics, we have to win the elections. Jorge, we're waiting for you.
Yes.
And that's it.
Thank you very much.